In July 2024, Daryl Jerel was charged with 2 counts of trespassing in the 14A District Court in Ann Arbor, Michigan. The charges, classified as misdemeanors, arose from 2 alleged incidents, one involving the use of an easement. Mr. Jerel was arraigned on July 24th, 2024, and the court scheduled a pre-trial conference for August 7th, 2024, before Judge Cedric Simpson. The pre-trial conference was intended as a case management hearing under Section 610 of the Michigan Court Rules, allowing the court to address discovery, motions, scheduling, potential plea agreements, and the status of the defendant's legal representation. Mr. Jerel was represented by Assistant Public Defender Lauren Perry, but communication between the attorney and defendant had been impossible due to Mr. Jerel's lack of phone, email, or reliable contact information. Recognizing this, Judge Simpson initially attempted to provide adequate time for Mr. Jerel to consult with counsel before proceeding. The case highlights fundamental principles of criminal procedure, including the Sixth Amendment right to effective assistance of counsel, as established in Strickland v. Washington, 1984, which requires defendants to have a meaningful opportunity to confer with their attorneys prior to trial. The underlying trespassing charges themselves were minor, yet the procedural circumstances would ultimately dominate the case's trajectory.
Miss Perry is so happy to see you.
I am very happy to see you. Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Jerel. Please state your name.
Daryl Jerel.
Okay. And where are we on his case?
Your Honor, we have not had contact practice today. I think the number we have for you
I don't have a phone. So whoever gave you a number, it was invalid.
Okay, so I'll need to figure out a way to get in touch with him so we can go over the case together.
So are there 2 separate?
If I give you my number,
What is?
you have a PO box?
I don't have a phone. I have a center. Use a PO box, I think.
Okay. Do you have an email address?
No. I'm on his radar. Use electronics.
All right. So you guys are going to be trying to figure out a way to make contact with each other, right? So.
Yeah.
Okay.
During the initial pre-trial conference, Judge Simpson addressed the communication barriers between Mr. Jerel and his attorney. Mr. Jerel had no phone or email, and the public defender had been unable to discuss the case with him. The judge sought to reschedule the pre-trial to September 4th, 2024, to ensure that Mr. Jerel could confer with counsel via letter, emphasizing the need to safeguard his constitutional right to effective assistance of counsel. Mr. Jerel expressed frustration at the perceived delay, repeatedly questioned the court about the holdup, and indicated his desire to leave the state. His responses escalated into a profanity-laced outburst directed at the judge. Judge Simpson warned him that such behavior constituted contempt under Michigan compiled laws sections 600.1701, 600.1711, and 600.1715, which permit summary punishment for disorderly, insolent, or contemptuous conduct occurring in the judge's immediate view. Despite the minor nature of the underlying trespassing charges, Mr. Jerel's conduct disrupted the proceedings and demonstrated a willful defiance of court authority. The initial debate thus shifted from procedural scheduling and counsel access to the defendant's behavior, highlighting the judiciary's responsibility to maintain order while balancing the defendant's rights and the efficient management of the court docket.
Well, the reason I say that is let me just do this. Let me give you a little bit of time so that I'm going to turn this out to September 4th, 2024, 9 a.m.
What's the holdup? It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing.
What do you mean what the holdup is?
This is it's an arraignment, right? Or a preliminary exam?
No. You're not charged with a felony, so it's not a preliminary examination.
Right.
You were arraigned in this on July 24th.
Mhm.
They set this date. Your attorney hasn't been able to talk to you about the cases at all.
Okay.
So I'm trying to I can set it for 2 weeks out.
Yeah.
But the problem,
I'm tired of the state. I'm ready to leave this state as soon as possible. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can kiss my ass. This is
you know what? You don't, no. I'm gonna tell you what, you don't come in here, you don't, fuck you. Okay, that's contempt, that's 93. Keep going.
Fuck you.
That's another
Fuck you
93.
again.
That's another 93.
Fucking game.
That's another 93. That's another 93. That's 6 93s consecutive. Close case, People versus Keith Yankton.
At the subsequent contempt hearing on August 13th, 2024, the discussion centered on Mr. Jerel's outburst and the appropriate sanction. Defense counsel sought to reduce the original 558-day sentence, emphasizing Mr. Jerel's remorse, personal hardships, and engagement with social services to address underlying issues. Mr. Jerel personally apologized, acknowledging his misconduct and loss of composure. Judge Simpson reviewed the context, noting that the initial outburst arose from frustration over communication delays and Mr. Jerel's challenging personal circumstances, including homelessness and unemployment. The prosecution highlighted the severity of the behavior as recorded on video, leaving the court to balance accountability with rehabilitative considerations. Judge Simpson explained that the pre-trial extension had been intended to ensure Mr. Jerel's meaningful consultation with counsel, not to provoke delay, and that contempt consequences were designed to preserve the authority and integrity of the court. The judge emphasized the structured nature of courtroom proceedings and the non-negotiable requirement for decorum, explaining that Mr. Jerel's conduct had escalated a minor misdemeanor into a serious liberty deprivation. Ultimately, the debate illustrated the court's dual responsibility to enforce procedural rules and address human factors that contribute to courtroom misconduct, while preparing to reconsider the sanction in a measured, fair manner.